Hello and welcome to our 5th short series webinar on the skilled worker visa. My name is Victoria.ounsworth and I'm an employment and immigration solicitor here at Filtymore Parks, and I'm going to give you an introduction to the skilled worker visa, which is the main immigration route for non-UK resident workers. In a world where businesses operate internationally, and particularly those who operate in more specialised markets, the need to attract talent from across the globe and to remain competitive and innovative is very important. For UK companies, sponsoring migrant workers under the skilled worker route is becoming increasingly popular. The UK job market has had to react to Brexit and other global events to maintain presence, and sponsoring migrants through the skilled worker route is no longer unusual. Here at FSP, we regularly assist startup companies and small businesses to obtain sponsorship licenses to allow them to recruit skilled workers from overseas and from within the UK. Sponsorship is a significant commitment to undertake, not only from a financial perspective, but from a legal one too, with compliance being a heavy burden for many employers, particularly in recent months with it being brought into the spotlight. The skilled worker visa route replaced the old Tier 2 general visa, which many of you may have previously known it by, on the 1st of December 2020. Whilst the formal resident labour market test requirements were scrapped, although watch this space, sponsors must still retain evidence of any recruitment activity they have undertaken before offering a role to a migrant worker. If the role was not advertised, the sponsor must be able to explain how it recruited that worker, and this can include job adverts, making record of where the job was advertised, who applied for that position, and any relevant evidence. This will help UKVI to establish where necessary that that role is a genuine vacancy. This is particularly the case when applying for defined certificate of sponsorships, which we'll look at further on. In order to qualify for a skilled worker visa, an individual must meet certain eligibility requirements. Now, these include: they must work for a UK employer who holds a sponsorship licence via the Home Office. They must also have a certificate of sponsorship from their employer with information about the role that they've been offered here in the UK. This information will include the role, job description, salary, hours, and personal details as well. They must do a job that is on the eligible occupations list. Now, unless the role that they've applied for is an eligible occupation, then individuals will not qualify for this skilled worker route. You must be paid a minimum salary dependent on what time you work and the date on which you were assigned a cause. There are provisions via the immigration rules for spouses, durable partners and dependent children to apply with individuals via this route. And it is also important to note that this route does provide a route to settlement and indefinite to leave to remain, which does make it more of a popular route for those wishing to settle in the UK more permanently. Individuals in the UK on another immigration visa can switch or change from a different immigration visa to the skilled worker visa if they meet all the relevant immigration requirements and were not last granted permission on any of the following visas: visitor, short-term student, parent of a child student, seasonal worker, domestic worker in a private household, or outside of the immigration rules or on immigration bail. Someone on any one of those routes would normally need to leave the UK and apply for entry clearance as a skilled worker. The main reason why an individual, for example on a global business mobility visa, might wish to switch is because the skilled worker visa, as I mentioned previously, provides individuals with a route to permanent settlement. As with the previous slide, we considered the various eligibility requirements for an applicant to qualify under this route. We are going to look at this in a bit more detail. The skilled worker visa is open to all non-British or Irish nationals aged over 18. Irish citizens do not need permission to live and work in the UK unless one of the exemptions applies, and are not eligible to apply under the skilled worker visa, given they are able to be employed in the UK without the need for sponsorship. Job role. Now, the role that you are going to perform must be an eligible occupation. To find out whether that job role that you've been offered is eligible, you will need to check that the occupation code. If you're unsure, CASCOT, C-A-S-C-O-T, is a useful occupation coding tool online and can help locate the correct occupation code for that role. Not every job title is included, and if you can't find your exact role, then search for similar roles with similar descriptions. It is important that the job description matches what you will be doing in practice. Some jobs are similar in nature, but will have different codes. For example, chefs and cooks. Chefs are eligible, whereas cooks are not. Once you've located your occupation code, you can view the table of eligible jobs on the Home Office website to see what is included. This table is very large, however, it is sorted by numbers. Salary requirements. You'll usually need to be paid the standard salary rate of at least £38,700 per year, or the going rate for your job, whichever the higher. You can find this list by searching the above term on gov.uk. This table is organised in order via occupation code, starting at the smallest number. The annual salaries contained in the table are based on a standard 37.5-hour week, and so if your role is higher than this, you will need to base the figure on the weekly working hours. Jobs will usually need to pay at least the going rate to be eligible for a skilled worker visa, but in some cases can pay less. The Home Office will take into account salary up to a maximum of 48 hours per week, even where the applicant might work longer. If they work part-time, then the Home Office will only consider their actual gross earnings to determine if they are being paid at least the general salary threshold. If an applicant's working hours vary each week, which is entirely possible, then work in excess of 48 hours per week can be considered towards the general salary threshold, provided the average over a regular cycle is not more than 48 hours per week. Unpaid rest weeks count towards the average when considering whether the salary thresholds are met, but do not count as absences for employment purposes. If you work in healthcare or in education, there are different salary rules. The going rates for these jobs will be based on the national pay scales set by the relevant independent body, for example, the National Health Service. Most applicants will qualify for the standard rate, where their certificate of sponsorship was assigned after the 4th of April 2024. If an applicant qualifies for the lower rate, for example, applying a health and care worker visa in certain occupations, or where you got your certificate of sponsorship for your first skilled worker visa before the 4th of April last year, and have continually held one or more skilled worker visas since then. So, where migrants are looking to extend their visa or update it, for example, where they have a new employer, they may be able to meet those lower salary requirements. You can also be paid between 70 to 90% of the standard going rate of your job if your salary is at least £30,960 per year and you meet one of the following criteria, as set out on the slide: postdoctoral position in science or higher education, science, technology, engineering, maths PhD level qualification, or if under the age of 26 and studying, or recent graduate or in professional training. So going to move on to consider eligibility further. On this slide, we see further eligibility requirements. You must have a job offer from an approved UK employer before you apply for a skilled worker visa. These employers are also known as sponsors because they are sponsoring migrants to live and work in the UK. The government does publish a list of approved sponsors, and it is prudent to carry out your own checks on any prospective employers, particularly where a migrant are doing the application process themselves. In order to complete an application, an employer will need to assign the applicant a certificate of sponsorship, and the certificate of sponsorship number will need to be on the application prior to submission. An employer is required to check that an individual meets the relevant requirements and that the certificate of sponsorship will demonstrate that that individual is eligible for that position. It is important to note that once a certificate of sponsorship has been assigned, the application must be made within 3 months of the certificate of sponsorship being assigned. We will look at this in more detail shortly. If you are a care worker or senior care worker, then your employer must be registered with the Care Quality Commission, also known as the CQC. An applicant will usually need to prove their knowledge of English language when they apply, unless they have already done so successfully in a previous application. An applicant is able to do this by passing a secure English language test or a CELT from an approved provider. There is a list available online. Have a GCSE, A-level, Scottish National Qualification Level 4 or 5, or Advanced Higher in English gained through a study at a UK school that individual began when they were under the age of 18. Have studied degree level qualification that was taught in English, and if they studied abroad, an applicant will need to apply through ECTIS for confirmation that the qualification is equivalent to a UK bachelor's degree, master's degree, or PhD. There are some exceptions to this requirement. For example, if you are a national of a certain country. You do not need to prove your knowledge of English if you've already passed an English language assessment that is accepted by a professional body, for example, as a doctor or midwife. The full eligibility requirements are set out at Appendix Skilled Worker to the Immigration Act, which are set out on the relevant websites. As before, we considered that an applicant must obtain a valid certificate of sponsorship before proceeding with their application, and that number must be provided with the application. Failure to give an appropriate certificate of sponsorship number can result in an applicant being terminated and the Home Office potentially carrying out a compliance visit on the sponsor. A sponsor must not assign a certificate of sponsorship to a worker for a role which amounts to the hire of an applicant to a third party, who is not the sponsor, to fill a position with them, whether permanent or temporary, or that would amount to contract work. A certificate of sponsorship can be assigned for up to a maximum of 5 years. Successful applicants will be granted entry clearance or permission to stay for the period of employment as stated on their certificate, plus 14 days, up to a maximum of 5 years. At the end of that continuous 5-year period, the individual may be eligible for indefinite leave to remain in the UK, and thereafter potentially naturalisation as a British citizen. If a skilled worker does not qualify for settlement by the time their permission ends, they can apply to extend their skilled worker visa if they are issued with a new certificate of sponsorship from their employer. There is no limit on the number of times an individual can extend their skilled worker permission, provided they continue to meet the eligibility requirements for that category. There are 2 different types of certificate of sponsorship, and the one which employer obtains will depend on a number of things. An undefined cause is used where the applicant is applying for a skilled worker visa from within the UK, or are applying for any other type of visa which requires a cause. A defined cause should be used where the applicant is applying for a skilled worker visa and they are making that application from outside the UK. It is important that the right type of cause is chosen, because if the wrong type of cause is issued to an employee, a sponsor could have their licence suspended or revoked as a result. How much does it cost? When an applicant applies for a skilled worker visa, their employer may agree to cover some or all of the costs in applying for that visa. Alternatively, applicants will need to pay some of the associated costs themselves. Unfortunately, it is not as simple as just paying one standard application fee. There are various different elements that are required. Firstly, application fees. These can vary between £719 and £1,639 and are dependent on the circumstances. If you are applying from outside the UK, the standard fee depends on whether you'll be in the UK for up to 3 years or more than 3 years. If you are applying to extend, switch or update your visa, the standard fee will depend again on length, with up to 3 years costing £827 per person and more than 3 years costing up to £1,636 per person. If your job is on the immigration salary list, then the applicant and any family applying with them will pay a lower application fee. The fee for this is £551 per person for up to 3 years and £1,084 if staying for more than 3 years. These application fees change on a regular basis, and for up-to-date fees you should check the Home Office website. The Immigration Health Care Surcharge is a fee paid by applicants who will be staying in the UK for more than 6 months. This fee allows migrants to access the NHS and the use of NHS services. A fee of £1,035 is payable for each year of the visa. Now this is a huge amount of money and increased from £624 earlier in 2024. Maintenance and support whilst in the UK. Ordinarily, an applicant must have at least £1,270 in their bank account to show that they are able to support themselves in the UK. This money must have been retained in the applicant's bank account for at least 28 days in a row. An applicant can be asked to demonstrate proof of these funds unless they have been in the UK with a valid visa for at least 12 months, or the employer can cover the costs during the first month in the UK. Partners and children must also prove that they are able to support themselves whilst in the UK. However, in most cases, an employer will indicate on the certificate of sponsorship that they will certify the maintenance requirement for the relevant migrant worker. This means that the sponsor agrees to meet the individual's costs of up to £1,270, plus a further £285 for a dependent partner and £325 for the first dependent child, with £200 for the others, up to the end of their first month of employment in the UK. In this case, no supporting evidence will be required unless specifically requested by the Home Office. Applicants will require various documents in order to complete their application, and I have listed the key information on this slide. COS, proof of English language, valid passport or other identity document, job title and salary, occupation code, and the name of their employer and sponsorship license number. Now, depending on the circumstances, individuals might be asked to provide further documents in support of their application. For example, evidence of personal savings for support purposes, proof of relationships where partner or children are applying together, tuberculosis test results if an applicant is from one of the listed countries, a criminal record certificate where an applicant has applied for certain roles, a valid ATAS certificate where a role involves researching a sensitive subject at PhD level or higher, or a copy of a UK PhD certificate where applicable, or the unique ECTIS reference number if the qualification an individual refers to is from outside the UK. To apply for a skilled worker visa, the applicant must submit an online application together with any supporting documentation and pay the relevant fees. They will also need to provide biometric information, and this can either be in the UK locally or overseas using the UK Immigration ID Check app. Now, timings are critical. Once a sponsor has assigned a COS, an application must be made within 3 months using that COS for entry clearance if outside the UK, or permission to stay where extending or switching. If a COS is assigned more than 3 months before the date of the application, then UKVI are likely to reject the application and the sponsor would need to assign a new COS to the individual before they can apply again. The individual must also start work within 3 months of the day the work date started on their COS. Now, timescales for approval will vary from time to time, and a guide will usually be available on the Home Office website. Once approved, skilled workers are subject to various conditions of stay in the UK. Now, these include no access to public funds. Skilled workers are not permitted to claim most state benefits or tax credits, or access homelessness or housing assistance from the state. Employment restrictions. Now, generally skilled workers must only work for their sponsor and as described on their COS. Minor changes to the details of employment are permitted, provided that the Home Office are notified via the SMS system and the worker continues to meet any other salary or other requirements of the route, and the change would not require a change of employment application. Workers are permitted, when making a change of employment application, to work out a contractual notice period for their existing employer, provided they were lawfully working for that employer on the date of the new application. Skilled workers are permitted to undertake supplementary employment, provided it meets certain requirements. It must be for no more than 20 hours per week. The worker must continue working in the job for which their COS was assigned. It must take place outside of their normal working hours for which the COS was assigned, and it must be one of the following: in the same professional position and at the same level as the work for which the COS was assigned, a job which is on the occupation on the immigration salary list, or a job which is in eligible SOC occupation code listed in Table 1, 2 or 3 of Appendix Skilled Occupations. Study restrictions. Now, skilled workers can undertake study courses if they wish, provided their study does not impact their ability to carry out the job they've been sponsored to do, and if relevant, they meet the ATAS condition. Study can be undertaken anywhere, and the individual chooses and does not have to be with a licensed student sponsor. There is no limit on the number of hours they can study or the level of course they can undertake. Now, it's important to note that the Home Office can take action against a skilled worker, their sponsor, or both for breaches of conditions of stay, including cancellation or shortening of leave, removing the worker from the UK, downgrading, suspending or revoking a sponsorship licence, and in serious cases, referring the sponsor or the worker to the police or relevant authorities. Going to look shortly at the health and care visa. Now, a health and care visa is a subset of the skilled worker visa and allows medical professionals to come to or stay in the UK to do an eligible job within the NHS, for an NHS supplier or in adult social care. This route has a number of benefits. It includes fast-track processing for entry to the UK, the support of a dedicated team within UKVI who specialise in processing applications of this nature, and any associated dependent applications, reduced visa fees, and an exemption from the immigration healthcare surcharge. Those applying under this route are still required to meet the standard immigration requirements of the skilled worker route, in addition to the specific health and care requirements. From the 4th of April 2024, the minimum salary threshold for non-shortage health and care visa roles was £29,000 per year, compared to £30,960 for those shortage roles on the immigration salary list. Unlike other skilled worker occupations, the going rate for health and care workers has remained in the 25th percentile. Some examples of those eligible occupations include biological scientists, pharmacists, psychologists, medical radiographers, dentists, occupational therapists, speech and language therapists, nurses, care workers, and senior care workers. If a worker is not to be employed under one of the eligible occupation codes, then they will not be eligible for a health and care visa and will have to qualify under the standard skilled worker route. From the 11th of March 2024, care providers in England cannot sponsor new care workers or senior care workers under the skilled worker route unless they are registered with the CQC. And there are also a few other requirements here. When assigning a COS to a skilled worker under this route or applying for a defined COS, the sponsor must include a brief explanation of how that worker meets the health and care visa criteria. If they're a private organisation, then they must also provide brief information about the contract or the agreement that it has with the NHS trusts or bodies who they provide services to. Applicants can include their dependents in their application to stay in the UK if eligible, although sponsored care or senior care workers making initial application after March 2024 are not eligible to be accompanied by their partner and children, including those who are already in the UK on any other route and where that route allows dependents who apply to switch to these roles. Care or senior care workers who are already sponsored can continue in their sponsored role and continue to reside in the UK and have eligible dependent family members accompany them or join them in the UK. As I said previously, one of the key advantages of the skilled worker route is that it is a route to settlement, where the worker meets the eligibility criteria for settlement. This is a significant advantage over the global business mobility routes, which do not lead to settlement. Workers must have been continuously and lawfully resident in the UK for 5 years, either as a skilled worker or in a combination of other categories, including global talent or innovator. Any applicant must still meet the knowledge in life in the UK requirement, and there is no further need to satisfy the English language requirement, as this is deemed to be satisfied after the initial application where this qualification or evidence was given. Applicants do require the support of their sponsor in order to be able to qualify for settlement on the visa. The sponsor must still be approved by UKVI in most recent application, and they must also confirm that they still require the skilled worker to work for them for the foreseeable future, and the applicant will continue to be paid for the foreseeable future at least the general salary requirement. Dependents can be included on the main applicant settlement application if they are eligible. Alternatively, they can apply separately at a later date, for example, where they are not eligible as they don't meet the relevant residence requirements, and this is quite common where they've joined the main applicant later on. It is advisable, particularly from an indefinite leave to remain perspective, that skilled workers keep an accurate record of any absences from the UK. This record should include the dates, places visited, and any other details such as why. This does help in constructing an accurate picture of the skilled worker's history over that 5-year period. Now, I appreciate this has been a whistle-stop tour of the skilled worker visa, and we have covered the key elements of the visa itself, what it costs and how to apply, conditions of stay, health and care visa, and obviously the route to indefinite leave to remain. If you found this session useful, please keep an eye out for the next webinar in our short series. Alternatively, if you require advice in relation to a skilled worker visa more specifically, then please do not hesitate to get in touch with our team, and I've popped my details there on the slide. Thanks very much for listening.